And you're Mr. Griffin, is that correct?
No, all statements for the record comes now the living man, Anthony of the Griffin family. Sir,
All right, so Mr. Griffin,
on appearing express.
wait, you need to stop talking. Is Mr. Griffin
appearing express
hearing today?
Yeah.
Are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin that is charged?
of
Stop a second here.
You asked me a question, I'm answering it.
Okay, I don't want you to answer it anymore. I want a yes or no answer to a question, okay? And the question is, and I have to get the case back in front of me, I'm sorry, but bear with me. Lost my calendar. I have a simple question for you.
25 CF 939.
Are you Anthony Griffin with a date of birth of August 20th, 1985?
I am not the dead entity Anthony Griffin. I am the executive of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then until we can have a later.
I am objecting, as I've been held for 72 hours without seeing a judge. That is unlawful.
But you're not Anthony
So
Griffin.
you are agreeing to violate my common law rights. Is that what you're saying?
I'm asking you to, let's do this. Okay. I'm going to find probable cause that this is Mr. Griffin, that is acting in an obstructing way, but we'll go ahead. Do you have a copy of the complaint there in front
I
of you?
object that you're obstructing my justice.
Your objection is noted.
I'm a more. You haven't
If you keep talking over me, we're going to cancel this.
Talking over me, I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
And you're not allowed. No, you're not allowed to talk about it.
Of attorney. I am not.
Okay, let's hold him in custody or canceling this hearing. You're going to have to be
That's
held.
okay.
You're not willing to cooperate. Make a
Let the record show that they're violating my rights. Let the record show that, please. Thank you.
Understand where the Drug Defender's Office refers to Mr. Griffin has indicated that he wants to take care of his own case.
Right. Is that right, Mr. Griffin?
No, I'm not Mr. Griffin. I'm Anthony of the Griffin. I am the power of attorney for Griffin. I do have a question for the court. Will I be allowed to speak freely, or will my civil rights be again granted over?
Oh, you get to make a statement on bail, but we're going to do this in an orderly fashion. But you're indicating that you're not Mr. Griffin, or that's just not how you identify yourself.
It's not about me identifying myself and the Griffin carries my all caps entity with the dead entity. I actually have an EIN for this created entity. This is not me. I also do not live this address. I'm also not a black man. I am a lawyer. So a lot of things on here totally wrong, which cannot be at all. My weight is not 240 pounds. All this information is false. But as for the record, all statements for the record comes now the living man and the other Griffin family. Sure, there is appropriate son status appearing expressly to continue the regular supporting. I'm not to be mistaken with the all caps estate, as I am the occupant of the executive office and also the sole beneficiary of the state. I found my power of attorney with the court, and I'm ready to proceed. Let the record show that I do not agree to be a surety for the dead entity as it was created from the state and was given to me and is not a representation of me. I am not one who owes debt to the United States or to the state of Wisconsin. Further, I'm not a flight risk. The only reason I'm supported would be the failure of the court to notify me of said date. Furthermore, on being detained, I made it very clear to Officer Gilson that I wanted my rights read to me. Officer Gilson first refused after we asked him twice more than he read me my rights. After Officer Gilson read me my rights, I made it very clear to him that I wanted my attorney present with the sheriff. Officer Gilson then replied, "They won't come." I made it very clear to him that if he continued to talk to me without my attorney present and the sheriff present, it would be a violation of my civil rights and my constitutional rights. He ignored these facts and continued to be arrested in violation of my law and the rights and the protocol that he agreed to follow as an officer. I was pulled over while I was traveling in a private automobile. The plates read, DOT exempt, do not detain private traveler. I made it very clear to him that he does not have jurisdiction, but yet he forced it. I was never properly identified as a suspect. My fingerprints were taken under direct arrest of origin after I told them I did not want my fingerprints or people taken until I have a court order from the judge. I do not argue with any of the facts in this charge against me. This is not me taking a plea. This is accepted for value and returned for value. All the charges contained in this case and use my exemption for discharge and set off and release the order to me immediately.
Okay. Well, I think there's at least reasonable inference on the record that, the person known as Anthony Griffin is the same individual in front of me. When the Anthony Griffin's case, he came out of the holding cell. I don't know why he would do that if he's not. I gave you an opportunity to speak. I'm speaking now, sir. You can object. There's no basis for it. I'm looking at the court records. Please don't interrupt. I'm looking at the jail records.
The Trust Act of 1666 says that when somebody claims their estate, you are to relinquish all of the things to them.
I don't know what you're talking about.
That's okay. That also means that this is not.
You can file your written motions,
Not a
Mr. Griffin.
competent court with jurisdiction, and I challenge jurisdiction under Federal Rule of Procedure 5.1.
It's denied. The booking photo and the filming records match this particular individual.
Like to approve your
I'll find
jurisdiction.
probable
No
cause.
man can be Lord over his own case.
And where would you like us to send mail, sir?
You already have mail, docs
Okay,
53532.
thank you.
And I have a record.
And what's the state's position on bail?
Thank you, Your Honor. In this case, the state is asking the court to impose $1,000 pound bail with the condition that the defendant be prohibited from possessing any dangerous weapons as defined by the respective statutes. It's my understanding that the defendant posted $5,000 cash on his current pending felony case and then failed to appear in court. He is alleged to have refused to identify himself and has committed additional crimes while out on cash bail, which is, as we know, a general violation of conviction.
I object.
It's our position that
Well,
cash bail-
Let her finish. We can't have this hearing. We are talking over people. We're trying to record it. What's the basis for the
the
objection?
basis for the objection is the fact that she has no basis of knowing who I am. I don't know who she is.
All right.
She's not even.
The objection's overruled. I ruled it, Mr. Griffin. Let her finish.
As far as that failure to appear, Your Honor, it looks like a bench warrant for a body only hold was issued on January 27th of this year in pending case 24 CF 907. That warrant was not served until almost 3 months later on the 17th of April this year.
So, Your Honor, they're sure not that when somebody has a court date that they have to be served a court date so they know that it's there? Or is it okay to actually set a court date without notifying the defendant or the accused and then locking them up for one?
All right, and I gather you're alleging that Judge Highland did not send notice to you?
No, there's no certified anything there. There's no documented proof of service of anything of that date. I went to every previous court date and I don't skip court date. He didn't show up for the last 3 court dates prior to that, and I actually put in a motion for failure to prosecute, yet they still moved forward as if nothing was placed in and no one came to court except for me and the prosecutor, and the judge was hiding in the back or whatever the case may be. I filed an abatement, just to let them know I'm not the person who they're looking for, but yet I keep getting trampled over in court. My rights keep trampled over in court. You have this person standing to the left of me who knows me not at all, and yet I would like her to take the stand and talk about how she knows me personally, because you cannot be a beneficiary.
Well, we're not going to be doing any of that, Mr. Griffin.
And she is not the state. I know her not. So I don't understand what's going on.
All right, well, it looks like they mailed notice to the address that you had on file at the time.
So
But you're going to have to take that up with Judge Highland. That case is not before me. Looks like he's issued a body-only warrant. You can't get release on that until you have a hearing with Judge Highland in that case. I think given the history, $1,000 cash bail is necessary. I will set that.
I object. It's clear that that's been violated and you're still moving forward. This is called an obstruction of justice.
Don't think that your rights have been violated.
Everything that I've said.
And that brings us to the final takeaway. Judge isn't deciding every issue, Mr. Griffin raised today, especially the separate warrant and whether notice was properly given in that. Other case, what the court can decide here is bail and the conditions attached to this proceeding, and despite all the objections, the judge ultimately keeps the $1,000 cash bail in place and adds a dangerous weapons restriction. So now the big question is, was this simply the court enforcing standard procedure, or did Mr. Griffin raise legitimate issues that deserved a deeper hearing? Either way, and thing is clear, arguing jurisdiction in court without accepting the court's basic identification process is rarely going to end the way you want. What do you think? Fair ruling or missed opportunity? Let us know in the comments.